On June 29, 2021, the Supreme Court of the Philippines issued AM number 210608SC, or the rules on the use of body-worn cameras in the execution of warrants. Here are the 23 questions and answers that you need to know. What is the scope of application of these rules? These rules shall apply to all applications, issuances and executions of arrest and search warrants and warrantless arrests. What is a body-worn camera? An electronic camera system designated to law enforcement units for creating, generating, sending, receiving, storing, displaying and processing audio-visual recordings that may be worn during law enforcement activities. What is an alternative recording device? An electronic camera system which is not a body-worn camera that is capable of creating, generating, sending, receiving, storing, displaying and processing audio-visual recordings and may be worn during law enforcement activities. It may be used as a substitute for body-worn cameras in case of unavailability. To be used as a functional equivalent, it shall comply with the following minimum standard requirements: video resolution 720 pixels or higher, frame rate 30 frames per second, audio built-in, data and time stamping, built-in GPS, built-in battery life, 8 hours continuous, storage, capable of storing 8 hours continuous audio-video footage, low light recording with night mode built-in, a low lux rating and/or an infrared IR illuminator. Who is a data custodian? An officer of the law enforcement agency implementing the arrest or search warrant who has the sole responsibility of storing and safekeeping data recorded from body-worn cameras. What is the meaning of recording? Digital material generated as a result of using body-worn cameras or alternative recording devices, which contains images and audio-video footages. It shall include the copies of the material created by way of copying to portable media storage and other data repositories. What is metadata? Information within the recording file containing any digital identifiers that are captured as part of the actual recording, such as the recording date, time, GPS coordinates, etc. Rules in cases of arrest. What is the rule regarding the use of body-worn cameras during an arrest? At least one body-worn camera and one alternative recording device, or such number as necessary to capture and record the relevant incidents during execution of the warrant, shall be worn by members of the team making the arrest by virtue of a warrant. Where a peace officer effectuates an arrest under Rule 113, Section 5 of the Revised Rules of Criminal Procedure, and insofar as it is practicable, the arrest shall be recorded using body-worn cameras or alternative recording devices in the same manner as an arrest made with a warrant. Further, in cases of warrantless arrests effected under Section 21 of the Comprehensive Dangerous Drugs Act of 2002, as amended, the media representative may be allowed to record the operation, subject to the custody requirements under Rule 4, Sections 1, 2 and 3 of these rules. When shall the body-worn cameras be activated and until when? Both video and audio recording functions of the cameras shall be activated as soon as the officers arrive at the place of arrest. Unless provided in Rule 4, Section 10 of these rules, the cameras shall not be deactivated until the arrest has been fully concluded and the arresting officers have delivered the person arrested to the nearest police station or jail, pursuant to Rule 113, Section 3 of the Revised Rules of Criminal Procedure. Is it necessary to notify the person to be arrested that execution of a warrant of arrest is being recorded? When making an arrest by virtue of a warrant, the officers wearing the body-worn cameras or alternative recording devices shall, as early as practicable, notify the person to be arrested and the other subjects of the recording that the execution of the warrant of arrest is being recorded and that they are making an arrest pursuant to a warrant issued by a court. What if a body-worn camera is unavailable? Should a body-worn camera be unavailable, at least two alternative recording devices must be used. The officers having such cameras shall ensure that they are worn in a conspicuous location and in a manner that maximizes their ability to capture a recording of the arrest. In case of malfunction, damage, or unavailability of body-worn cameras, resort to alternative recording devices may be allowed. Reasons for resorting to such alternative devices shall be explained in the affidavit to be submitted to the court under Section 4 of this rule. Where will the recordings of the body-worn camera be stored? All recordings from the body-worn cameras or alternative recording devices used during the execution of the warrant shall be stored in an external media storage device and simultaneously deposited in a sealed package with the issuing court, provided that the officer may, with leave of court, retain a backup copy for justifiable reasons for a period not exceeding 15 days. What is the effect of failure to use a body-worn camera on an arrest made? Failure to observe the requirement of using body-worn cameras or alternative recording devices shall not render the arrest unlawful or render the evidence obtained inadmissible. Facts surrounding the arrest may be proved by the testimonies of the arresting officers, the person arrested, and other witnesses to the arrest. However, a law enforcement officer who fails without reasonable grounds to use body-worn cameras or alternative recording devices, or intentionally interferes with the body-worn camera's ability to accurately capture audio and video recordings of the arrest, or otherwise manipulates such recording during or after the arrest, may be liable for contempt of court. Liability for contempt of court shall not apply if the body-worn cameras were not activated due to their malfunction and the law enforcement officers were not aware of the malfunction prior to the incident or when allowed under Rule 4, Section 10 of the rules. This is without prejudice to any administrative, civil or criminal proceedings that may be initiated against him or her for the same acts or omissions. Failure to timely file the affidavit as required under Section 4 of this rule may likewise render the law enforcement officer liable for contempt of court. Rules in cases of search. What is the rule regarding the use of body-worn cameras during a search? Well, at least one body-worn camera and one alternative recording device, or such number as necessary to capture and record the relevant incidents during the execution of the warrant, shall be worn by members of the team conducting the search by virtue of a warrant. Should a body-worn camera be unavailable, at least two alternative recording devices must be used. The officers having such cameras shall ensure that they are worn in a conspicuous location and in a manner that maximizes their ability to capture a recording of the search. When shall the body-worn cameras be activated and until when? Both video and audio recording functions of the cameras shall be activated as soon as the officers arrive at the place of search, and the cameras shall not be deactivated until the search has been fully concluded and the officers conducting the search have left the premises and returned to the police station. Is it necessary to notify the occupants of the premises to be searched? When conducting a search by virtue of a warrant, the officers wearing the body-worn cameras or alternative recording devices shall, as early as practicable, notify the lawful occupants of the premises to be searched that the execution of the search warrant is being recorded and that they are conducting a search pursuant to a warrant issued by a court. What is the effect of the failure to use a body-worn camera during a search? Failure to observe the requirement of using body-worn cameras or alternative recording devices without reasonable grounds during the execution of the search warrant shall render the evidence obtained inadmissible for the prosecution of the offence for which the search warrant was applied. A law enforcement officer who fails to adhere to the requirements during the execution of a search warrant or intentionally interferes with the body-worn camera's ability to accurately capture audio and video recordings of the search or otherwise manipulates such recording during or after the search may be liable for contempt of court. Liability for contempt of court shall not apply if the body-worn cameras were not activated due to their malfunction and the law enforcement officers were not aware of the malfunction prior to the incident. This is without prejudice to any administrative, civil or criminal proceedings that may be initiated against him or her for the same acts or omissions. Failure to timely file the affidavit as required under Section 6 of this rule may likewise render the law enforcement officer liable for contempt of court. What is the remedy available if the search violated these rules? In addition to the grounds allowed under the revised rules of criminal procedure, a motion to suppress evidence may be filed by a person searched if the search was done without the use of body-worn cameras or alternative recording devices, and the failure to use such cameras is without any reasonable ground. This remedy shall likewise be available to persons searched incidental to an arrest by virtue of a warrant, when such arrest was without the use of body-worn cameras or alternative recording devices without reasonable ground. What is the rule on the chain of custody over the recordings? The chain of custody over the recordings shall at all times be preserved from improper access, review and tampering. It shall cover the following events. First, recording of the footage using the body-worn cameras or alternative recording devices. Second, turnover of the body-worn cameras or alternative recording devices used by the arresting or searching team, or of the data by the media representative under Rule 2, Section 3 of these rules to the data custodian of the law enforcement agency to which they belong. Third, downloading of the data by the data custodian pursuant to Section 1 of this rule. Fourth, redaction of personal identifiers by the data custodian or his or her representative pursuant to Section 4 of this rule, whenever applicable. Fifth, retrieval of recording data and their transfer to an external media storage device by the data custodian. And finally, submission and delivery of the recordings contained in an external media storage device to the court under Rule 2, Section 4 and Rule 3, Section 6 of these rules. Who has custody and access to the recordings made? The data custodian of the law enforcement unit employing the officers whose body-worn cameras or alternative recording devices captured the recordings, or to whom data was turned over by the media representative under Rule 2, Section 3 of these rules shall retain and have custody of the recordings, and he or she shall ensure their security, confidentiality and integrity. Prior to submission to the court under Rule 2, Section 4 and Rule 3, Section 6 of these rules, the data custodian or any other person in custody of the recording shall limit viewing access of the footage to any person who is a subject of the recording or his or her counsel, the parent, guardian or counsel of any minor who is a subject of the recording, the spouse, next of kin, or legally authorized designee of a deceased subject of the recording or his or her counsel, and employees of the law enforcement agency to which the officer whose camera captured the recording belongs. Data recorded by body-worn cameras and alternative recording devices are not public records subject to disclosure, unless the recordings involve an incident resulting in a loss of life or an assault made on law enforcement officers during the arrest or search. Recordings and copies of such recordings that depict or record circumstances in which a person dies while being apprehended by or while in the custody of law enforcement officers, or when assault is made on law enforcement officers, are considered public record. Is consent of the persons affected necessary to use the recording in a court proceeding? Consent of the person arrested, or those affected by searches and seizures to the use of the recordings resulting from the use of body-worn cameras or alternative recording devices in a court proceeding shall only be asked in the presence of counsel. If the person consents or remains silent, the recordings may be used by and against him or her in a court proceeding. If he or she declines, the recordings may not be used by or against him or her. In case of minor subjects, consent shall be secured from his or her parent or guardian. The lack of consent to the use of the recording shall not delay the conduct of the arrest or search in accordance with the warrant issued. Who shall be entitled to obtain a copy of the recording? The following persons shall be entitled to obtain a copy of the recording within 5 days from data downloading, should the person subject of the recording consent to its use in a court proceeding, to wit: 1. Any person who is a subject of the recording or his or her counsel. 2. The parent, guardian or counsel of any minor who is a subject of the recording. And 3. The spouse, next of kin or legally authorized designee of a deceased subject of the recording or his or her counsel. They shall not release such recording to other persons, including the media, before and after use in trial. A violation of this section may constitute contempt of court. May a witness be substituted by the recordings made under these rules? For evidentiary purposes, the recordings captured by body-worn cameras or alternative recording devices are supplementary to the testimonies of the persons subject of the recording or the law enforcement officer. The recordings shall not be deemed as substitutes for the presentation of witnesses. What are the circumstances where use of body-worn cameras or alternative recording devices may be turned off? Body-worn cameras or alternative recording devices shall be turned off during the following circumstances during the arrest or search. 1. Communications between law enforcement personnel unrelated to the conduct of the search or the arrest. 2. Encounters with undercover officers or confidential informants. 3. When law enforcement officers are on break or otherwise engaged in personal or non-work related activities. 4. Inside restrooms, locker rooms or other places where there is a similar expectation of privacy and there is no legal reason to be present unless the premises are covered by the search warrant. 5. In locations where individuals have a reasonable expectation of privacy, such as in residences, unless the recording is being made pursuant to a valid arrest or search warrant of the individuals or locations. 6. Strip or body cavity searches when such is necessary as provided in the warrant. 7. Conduct of tactical planning before conducting the search or the arrest. 8. Privileged communications between the subject of recordings and other individuals, such as attorneys, members of the clergy, peer support counsellors and medical professionals. 9. Such other circumstances as may be provided by the trial court issuing the warrant, which is part of constitutional privilege, and where the dignity of an individual may outweigh the public necessity